not a springing power of attorney. Now, the statute does not specifically speak to escrowed powers of attorney, but it specifically says that a power of attorney can provide that either a copy is as good as an original or that you need the original to use it. So that was the legislature's secret cure to the springing power of attorney question. I'm sorry, escrowed powers of attorney with escrow agreements. Now, something else to keep in mind is if you have a client who wants a springing power of attorney, get them to come in and sign it by September 30. We have some clients who have done springing powers of attorney for us, and we're going to have them come in and re-sign them in September so that they're fresher. If I have a client who gave me a springing power of attorney 5 years ago and still wants me to have the springing power of attorney before the end of September, as long as they understand what it means. Now, page 18, near and dear to our hearts, is the revocable trust. Clients are going to be maybe more inclined to set up revocable trusts here that would spring because you can say, I am my own trustee, I place these assets in the trust, but in the event of my incapacity, the alternate trustee is, and then that can be anyone you name. These limitations that apply under the new power of attorney statute, curiously enough, do not apply under the Florida revocable trust statute, even though revocable trusts hold a lot more assets on average than someone would act under a power of attorney for. Probably the reason for that is that people are considered to be more sophisticated in the revocable trust context. Page 19, I just want to mention, you may want to put a clause in your power of attorney as long as you're updating your form to prevent financial scams or to prevent whoever you appoint as your agent from getting mixed up in financial scams during this age of the Madoff-Perlman world. Okay, there's more information in the subsequent pages, but I wanted to cover this in 15 minutes. Provision, and Christy Nicola, who I've mentioned before, is going to give this provision. Thank you very much for joining us, and have a great evening. Chris?
Thank you, Alan. And as Alan had mentioned, gifting under a power of attorney requires a separate enumeration by the principal in the power of attorney. And this is something that's new under this new power of attorney law. One thing to keep in mind is that an agent can make gifts on behalf of a principal, but unless that agent is someone that's legally obligated to be supported by the agent, then gifts cannot be made unless the power of attorney explicitly authorizes that. So that's something to keep in mind here. And I'm just going to back up one slide here on slide 20. You'll see that this is language pretty much paraphrased out of the section 709-2202. One other key component to the gifting provisions is that unless the power of attorney provides otherwise, the agent can only make gifts of up to $13 annual exclusion for 2011, or up to $26,000 per year if the principal is married at the time of the gift, and plus the agent can go ahead and join in a split gift tax return for any gifts made by the spouse of the principal. And this is important because we have a lot of well-to-do clients that want to make use of this increased $5 million lifetime gifting exclusion. Then the power of attorney would have to otherwise provide, or else the agent would not be able to make gifts to take a look at and think about when redrafting power of attorney documents. Okay, on slide number 21, I've listed here the federal tax implications of agents' authority to make gifts. Now, some of this area is a little bit unsettled. One thing is for sure is that granting the agent a power to make gifts by itself is not a taxable gift so long as the power of attorney is revocable. And this goes along with the principles of a gift under state and local law in that a modification or revocation of a gift, that you don't have a gift under state or local law or even federal gift tax law. So that's something to consider. Now, if the agent go ahead and makes the gift, then you have a gift for federal tax purposes occurring at that time. And it's important to keep in mind that the gift must be effectively delivered to the donee of the gift for it to be considered as complete under state, local law, as well as federal gift tax law. And this means that clear as to whether delivery is presumed if the agent is the recipient of the gift, but it seems quite likely that that would be the case. Now, there's another issue out there regarding whether the ability of an agent to make gifts to himself or herself is a general power of appointment for gift tax purposes. Now, a general power of appointment means that the assets subject to the power would be includable in the estate of the agent. And the general power of appointment is creditors to one's estate or to the creditors of one's estate. And there's gift and estate tax considerations with that, especially if an agent serving under a power of attorney has substantial assets, and this general power of appointment would cause more assets to be included in the estate of the agent. Now, there's conflicting arguments regarding this. There is no case directly on point, and one side to the argument is that a general power of appointment for federal tax despite the fact that it may not be labeled as a general power of appointment, and some other type of nomenclature may be used in creating the power, the converse to this argument is that if the power of attorney is revocable, then the donor could revoke the agent's gifting power, and in that case you would not have a general power of appointment, because any power of appointment that's only exercisable with the consent and joinder of the principal does not in mind. It's advisable to certainly draft power of attorney documents to limit an agent's power to make gifts if gift or estate taxes are concerned. With Alan mentioning earlier, we're preparing new forms for our clients to take into account this new law. It's important to make sure that the forms say what we intend, and we certainly don't want unintended tax consequences here, amongst other ramifications that could occur if the forms aren't what is intended. And that concludes my discussion of gifting. I believe that concludes our webinar, and I want to thank you for joining, and we do appreciate your attendance, and please visit our website to see other webinars that we have in the future, and we hope to correspond with some of you soon.
Chris, thank you very much, and all of you who have attended, we appreciate any questions, comments, or suggestions you might have. We will be scheduling one of these for about a week and a half